All right, good afternoon, everyone. I hope you're all doing well. My name is Homera, and I'm the chair of the Prince George's County's committee called Professional Enhancement Committee. And today we have with us Scott Sweitzer, and he is the presentator. I'm sorry, he's the speaker for today. Um, Scott's a graduate of Georgetown Law Center, and he has a bachelor's from the University of Chicago. And Scott's been practicing law since 2010. He's also licensed in the state of Virginia, Maryland, and the District of Columbia. He focuses on estate planning for parents with minor kids, the LGBTQI plus community, and real estate investors. He's also is the owner of a title company called the Prime Settlement, and they service DC, Maryland, and Virginia. Scott, I'm going to go ahead and hand it over to you.
Okay, Mira, thank you very much. I'm really excited to be here in front of the crowd today. I know a lot of you out here in the part of this organization, and it's a great honor. So really. Like was just said, my background is in title and real estate. And actually, I moved to the DC area 21 years ago now. I'm from Wisconsin originally, moved to Chicago for school, and then came out here and have been here ever since. And I started out clerking for a real estate attorney, doing condominium conversions and things like that. Quickly moved on to a title company, worked there for a few years, and went ahead and actually opened my own title company, Prime Settlement, which is currently in operation. And it was in 2017. I'd been part of a law firm before that, but in 2017, upon the death of my grandparents on my mom's side, and then the death of my great aunt and uncle on the other side of the family, that I really got inspired to shift my focus towards estate planning. And it was interesting. I mean, what had happened was on my mom's side, my grandparents went to a really good estate planning attorney, and they took my mom, and they took her brother, and they explained exactly what was going to happen when they passed away. They created what's called a revocable living trust, and I'll talk more about that later on. But they created that, and they explained how the distributions would work and so forth. And when my grandparents did pass away, my mom and brother, her brother, went back into the same attorney's office, and they administered the trust. And because of the way that they did things, the entire process took under 4 months. So it took under 4 months. There was no court, no probate court, and it was completely collaborative. And it actually brought that side of the family closer together because they were working on this together, and it was a really nice experience. So we had that on the one side of the family. Unfortunately, the other side of the family had sort of the opposite experience. My great aunt and uncle were wonderful parents and so forth, but they had a mindset around money and around death where they just didn't want to talk about it. They didn't share information about finances with their family. I think perhaps they had the mindset because they felt like they didn't have a lot, that their kids would just pick up the pieces when they died. So they didn't create a trust. In fact, they didn't do anything. So when they did pass away, their estate went right into probate court in Wisconsin, and their kids started fighting, unfortunately. And they started fighting about silly things. They fought about who gets grandpa's wood saw and things like that. And they all hired their own attorneys to litigate in court, and because there was no will. And at the end of the 3 years of litigation, the cost of the legal fees and the court fees just about equaled the value of the estate. So nobody got anything. And to this day, there are people on that side of the family that aren't speaking to each other. And I know that if my great aunt and uncle had realized that that would have been the outcome of their lack of planning, they would have taken the time and they would have put the money into doing some planning. So for me, seeing that disparity of outcomes in my family made me realize that in my role as a title attorney, as a title agent, I saw people coming and going and having transformational experiences, people that were selling their properties because they were downsizing or getting married or getting divorced or someone had passed away. And I could really help them. I could really help educate them on how to own their property better and make a meaningful impact to the community. And that's really what I want to share with you all today here, because you're in a position as realtors or people that are affiliated to the real estate industry to really educate your clients on how to own your property better and really how to make family transitions and intergenerational wealth a possibility. So let me go on to the next slide here real quick. And I'm guessing that many of you here are here in your professional capacity. You know, you're probably here to learn how to help your clients leave real estate for the next generation. But I know that some of you are here because you want to help your own families. So as I go through the next few slides, I'd appreciate it if you would go ahead and post in the chat and just let me know why you're here today, and what motivated you, what you're looking for, because that's going to help me tailor this conversation a little bit to the people that are here. And I love that kind of interaction. So, you know, reasons people come to these kind of presentations, you could be here because you are concerned about making sure that your assets are passed, or your clients' assets are passed from one generation to the next in the most efficient way possible, avoiding probate court, avoiding creditors. You may be here because you want the assurance and comfort knowing that your kids or your family's gonna be taken care of when you're not there to look after them. You may also be focused on taxes. You may be looking at estate taxes. You may be thinking about how to minimize income and capital gains taxes. You may know that there's a lot of tricks out there and you've heard of some of them, but you're not quite sure how they all apply to you. You also may be thinking about what happens in terms of your own health. If you get in an accident or get sick and are not there to make choices for yourself, you want to make sure, you may want to make sure that your own healthcare choices, your choices about your own well-being, and perhaps your end of life are respected, and that the people that you want making those decisions are empowered to do so. The wrong people aren't there in that role. So, you know, any of these situations are in a sense, good reasons to be here today. So I'm going to go ahead and take a look at the chat real quick and just see and we're getting a lot of responses here. So this is awesome. I really appreciate that. I'm just going to go through here real quick. So I'm seeing here, Danielle, preparation for your own family. Brenda, you're here for your clients and family. Great, great. Walker, distribution of family assets. Good, we'll get into that. Alan, professional and prep for family. William, family. Okay, so there's a lot of you on here that are actually interested in your own family as well as your clients and everything. So that's fantastic. Boyd, your vision for generational wealth and to help your family. John, refresher on living trust. We're definitely going to go into that. Jackie, you're here for your blended family, mom and stepfather of adult kids. That's fantastic. I don't plan on going into that in a lot of detail in this presentation, but I have a lot of clients with blended families. So please, when we get to the end of the webinar, please make sure to drop your information in there so we can follow up personally. Okay, so that's great. So that's fantastic. I'm glad for that feedback. Thank you so much for that. I appreciate that. Let me just move this chat over real quick here. For those of you, and I just wanted to think about this too, for those of you who have done some estate planning, whether it's just getting a will online, working with attorney 10 years ago and so forth, or, you know, doing kind of a hodgepodge of documents, powers of attorney and so forth, you know, just think about when was the last time you reviewed your estate plan. What I find a lot in this industry is that people do something, whether it's they do it themselves or they work with an attorney, but they set it and they forget it. They don't have an ongoing system or process of reviewing their plan that makes sure that it's up to date with their own life and their own experiences and their own needs at the time. And I do want to talk a little bit about what the state's plan for you is. So if you do nothing when it comes to estate planning, your estate, and that's the assets that you own when you pass away, will be governed by the laws of what is called intestate succession. Intestate succession. What does that mean? Well, it means that the state law has done its best job to decide who's going to get your assets and what happens. And what that means is that your assets fall into a court process called probate, and the state's going to say who gets your assets. It may give, you know, a portion to your spouse if you're married. It may have assets go back up to your parents if they're still alive, a certain share down to your kids, and then out to your siblings and things like that. And the state of Maryland or Virginia or DC, they're trying to do the best they can to kind of preserve the family structure and so forth. But the state plan is not going to work for you if you have people in your world or organizations that you want to benefit that aren't part of the traditional bloodline family tree. It's not going to help out if you have people, kids that you want to protect, but who may not be in a position to manage money well. or who may be married to somebody who would take the money away, or who might have special needs, or be part of a blended family. The state's law plan, intestate succession, is not there for that type of planning. So really here, planning for death, and I'm just going to talk a little bit about what I see out there in the legal field. This is if you are going beyond doing it yourself. There are a lot of estate planning attorneys out there who view this is a real transactional field. You'll meet with them, they'll give you a set of documents, and that's basically it. And it's funny, that's where I see a lot of people coming into me telling me that, hey, I worked with an attorney, we did these documents 10 years ago, but I have no idea what we didn't do anything after that at all. We really didn't we didn't make any plan, and they're not sure if it's going to work. And actually, I have a really interesting story in my own practice. Again, running my title company, and this was several years back, and this is when interest rates were super low and getting lower. And I would have unmarried couples come to me, and they'd say, we want to buy this property together, but because we're not married yet, we just want to have a plan in place for what happens if this relationship doesn't survive. What happens if we never get married? What happens if we break up? So I would refer them to a trust and estate attorney, because I wasn't practicing at the time, who would create a revocable living trust for them and put memorialize those plans in place and so forth. But the key was, in order for a trust to work, the trust has to own your property. You have to use the deed to move the property from your personal names into the trust. And that's going to make it work. And that's going to make it avoid probate. I'll get into that more later. What I found was a lot of times is these same clients would come back to me, and they'd be refinancing because back in the day, the rates were going down and so forth. And 9 times out of 10, I noticed that the property was still held in their personal names rather than the name of the trust. So I'd ask them, I'd say, oh, did you not like the attorney that I referred you to? Was that a bad fit? And usually they'd say, no, Scott, he was great, or she was great. Thank you. We appreciate the referral. So I get curious again, and I'd say, well, did you do some other type of estate planning then? Did you guys, create some other kind of agreement, but you didn't create a trust? And again, 9 times out of 10, people would say, oh, we created the trust. We've got it here. We paid $4,000. It's sitting on our living room table or the shelves. Again, thank you. And I would be in the kind of uncomfortable situation of having to let them know that they had a trust, they had a set of documents, but their property was still owned in their own personal names. And if they were to get in an accident the next day, all the planning they had done would be for naught. That their family would be back in probate court. They'd be back in a situation as if they never actually created the documents. And at first I thought, that the attorney that I referred them to was doing a terrible job. I thought it was malpractice, but in fact, it was common practice. Most of the attorneys have, transactional practices. They bill by the hour. You meet with them, they set documents. They may mention to you that, oh yeah, you have to fund your trust. You have to make sure your assets are owned correctly, but they don't work with you to get that done. And 9 out of 10 people don't finish up the process themselves. So they have an estate plan in place, but their assets are owned improperly. So when I started my process, I wanted to make my practice. I wanted to make sure that that never happened to my clients. So again, just a little bit about what I think is a better way of doing estate planning. It's important to have a consultative approach, relationship with your estate planning attorney. Think about it as if you had a financial planner. You would never go into their office and put in place a financial plan and never communicate with them again, and assume that 10 years later, or when you're ready to retire, that the plan you put in place would work, would be relevant anymore. You know that it's an ongoing relationship, that you have to review things. And that's the way it should be for estate planning, because your family situation, your financial situation, and the law consistently changes. So it's important that you're working with an attorney that really isn't just producing a set of documents, that they're following up with you, that they're meeting with you, they're meeting with your siblings, potentially your parents, making sure that the family is working together, because that family generational wealth transfer that one of you asked me about, that's not going to happen unless all the families on the same page, unless people understand what's going on. So, and that's how kind of I view myself. Actually, what I really enjoy doing the most is counseling my clients through their tricky family situations, whether it's a couple who aren't on the same page about what should happen, whether it's a blended family who have kids from different relationships and they're trying to keep everyone happy, even though they're not all have the same relationship, whether it's parents with kids with special needs, or if it's people who are in their 70s and one of them has a diagnosis of Alzheimer's or some other kind of debilitating disease that means that they need long-term care for a long period of time, and they're terrified that they actually may become impoverished by the cost of long-term care, and they may end up, being broke. Those are all things that you want to be able to rely upon your attorney for. So I'm curious here, probate court. Who here, and this is another question that I have here, you can put it in the chat. Most of you here are realtors. So who here has had a client who's their client or their family has gone through probate court before? Perhaps it's been an estate sale, perhaps it's a property that you thought you could list right away, but actually it took 6 months, 9 months, a year longer than you anticipated because they had to go through probate court and it wasn't as easy. Just share a little bit about that, your stories. I'm gonna look at the chat real quick. So I'm saying yes. Otley, Littlefield, you, and then Michael Page, this is your specialty. And then Cindy, you've been through probate court personally. Okay, that's great. Yes, several, yes, okay. You with the family. So yeah, the probate court process is what we have in the United States, and it's there to deal with your estate when there's not a plan in place, and it's there for the benefit of your creditors. So when you pass away, they want to make sure that your creditors be put on notice and have an opportunity to come forward and make a claim against your estate and to get the money before your kids or before whoever you want to is able to inherit. Costin, I see almost 2 years later and still going with a probate with a will. Yeah, probate is expensive, it's time consuming, and it's open to the public. So anything that happens in probate, anything that happens, the personal details of your family, hopefully not fighting, but maybe fighting, like in the case of one side of my family, that's all open to the public. And I think a common misconception that I find with people, when they think about estate planning, our culture teaches you to think about a will, and that's totally fine. A will is better than having nothing, a will is better than dying intestate, but a will is meant to go through probate. It's meant to go through that process. It tells a judge in probate how your assets should be distributed. We've got one here of Jackie Kennedy Onassis, the classic, just because there's a lot of celebrities out there with massive estates, with all sorts of assets, and there's more, more relevant, more recent examples of people who died a little bit younger without planning in place, who go through the probate court process and are stuck for years, and it's super expensive. My estimates, colleagues of mine typically put the cost of going through probate to your estate, basically to your beneficiaries, is usually about 5% of the value of the estate, including real estate, including life insurance, including retirement accounts. So it adds up pretty quickly, and it's a lot more expensive than the cost of avoiding probate, which I'll get into next. Some other negative effects of dying without a plan in place or just a will-based plan is that your beneficiaries, those may be your kids, they may be minor kids or kids just turning 18. They receive their assets, what are called outright or unprotected. So if you have a life insurance policy with $500,000 and you get a spouse and you're a single parent with a kid, that money will be held until they're 18, and then they'll get an outright distribution of $500,000 as an example. I was a pretty responsible kid, but had I inherited $500,000 when I graduated from high school and had no parents, I think I would have made some bad decisions with that money. I don't think that the money would have been that helpful. I don't think I would have had that money today. So one of the problems with leaving it up to the state's plan is that your kids, if you have them, if there are assets that they inherit, they may actually hurt the kids rather than helping the kids. And at the very least, the assets are probably not going to last as long as they should. So again, even if you have a will, one of the things I want to point out is that when I give presentations with clients that have minor kids, so young kids, a lot of them will have a will in place, and it will list who would be the guardians, who would be the long-term guardians of their kids should they pass away. One thing I'd like to point out is that a best practice is not just to list your guardians in a will. You should actually have long and short-term guardianship nominations as separate documents, because a will takes in place only if you die, when you die, through a probate process. But some clients, some people don't die, they get in an accident and they're incapacitated, or they become disabled. And in that particular case, the decisions you put in your will aren't going to actually take effect. So a probate court, a judge, will then have to decide who takes care of your kids. If you have guardianships in place, that won't happen. As soon as you lose capacity, as soon as you get in an accident, as soon as something happens, your guardians will be able to step in. And I advocate not only having long-term guardianships, the people that you actually want to raise your kids, but having short-term guardians, people that would step in if your kids were with a babysitter and somehow you and your spouse never made it home, so that your kids don't, so the babysitter doesn't have to call the police, and your kids don't end up in protective custody, which can be very traumatic for the kids. Finally, any good estate plan, any foundational estate plan is going to address basic incapacity planning. So you're going to put in place what's called a durable power of attorney. You're going to nominate the people who are going to manage your financial affairs if you get sick or if you get in an accident. You're also going to be putting in place a medical power of attorney and a living will. That'll nominate the people, and they may be the same people, they may be different people who are making healthcare decisions on your behalf. And the living will is also going to talk about how you want your end of life care to be treated. And that's something I think a lot of people don't think about because they don't want to contemplate getting sick or getting in an accident. But it makes it a lot easier on the family if the right people in your family can step in and make those choices, again, without having to go to the probate court and petition the court to get access. So that's a key part of any estate plan. You want to make sure those are in place. So here, actually, this is something that I love to talk about a little bit, and you've probably seen this as realtors quite often. I know as a title attorney, having my company, I get this all the time. People, especially as they get on in age, in their 60s and 70s, they're aware that they want their property to avoid probate, for example. And they come up with, a friend tells them what to do, or even maybe a title attorney might tell them as a solution. They'll have piecemeal solutions that they'll try. And a common one is they'll say, hey, I'm going to add my kids to title. So I'm going to own this property jointly with my kids. And I came across that a lot before I was doing estate planning. As a title attorney, people would just make a request. They wouldn't give me the full context. They would say, hey, can you draft a deed to add my daughter to title? And yeah, I would say, sure, I can. You know what I mean? I know how to draft deeds, I know how to record them, in the land records. We can do that. But at that point, I wasn't questioning my clients. I wasn't asking them why they wanted to do this. And, as a result, I wasn't getting the full context of what's going on. So I wanted to share a story that I think may resonate with some of you. I call it Helen's story. And what happened is one of my financial planners that I work with contacted me to try to help her client, Helen. Helen was trying to make sure their property in Tacoma Park didn't fall into probate court when she died. Unfortunately, she had already worked with a title attorney who suggested that she add her 2 daughters to title. The title attorney was trying to help, but he wasn't an expert in estate planning, and he didn't realize the downsides of this strategy. So I went ahead and I pulled the deeds from the land records. Helen and her daughters were now all owners of Helen's house. Unfortunately, the title attorney didn't specify the tenancy of the new owners on the deed. Some of you may have known this already, but when a deed is silent as to the tenancy with multiple owners, the default tenancy is tenants in common. Since tenants in common doesn't have the rights of survivorship, when Helen dies, her share of the property will not pass straight to her daughters. Instead, it will go straight into probate court, which is exactly what Helen was trying to avoid. Beyond that, one of Helen's daughters had recently gotten divorced and lost her job. Unbeknownst to Helen, she racked up a lot of credit card debt and couldn't keep up with the payments. She defaulted on her debt, and because she owns 1/3 of the property now, her credit debt went into collections, and the collection company recorded a lien against Helen's property. Helen wanted to know how we could help her get rid of the lien, since she already paid off her mortgage and she didn't have consumer debt. Unfortunately, she was stuck with the lien and had to decide whether to pay off the $75,000 of her daughter's debt, despite the fact that her daughter was over 40 years old. And then finally, in my research, it showed that Helen had purchased her property, this is again Tacoma Park, in 1982 for about $120,000. It was now assessed at $1.2 million. Sounds crazy, but a lot of the property in the DC DMV area, if you look back 40 years, it's sometimes has gone up to that level, like a tenfold increase. And one of the most valuable tax minimization strategies when it comes to real estate is using what's called the step up in basis that occurs when your kids or other beneficiaries inherit your property. So for example, if Helen decided to sell her property at $1.2 million, she would owe capital gains tax on the difference between the purchase price, $120,000, and the sales price, $1.2 million. Because it's her primary residence, the current law would exempt some of this from tax, but she'd still have a sizable bill. However, if she retained ownership of the property until her daughters inherited, they would get that new basis of $1.2 million. And what this means is that if they turned around and sold it for $1.2 million, there would be no capital gains tax owed. It's a huge savings. It's hundreds of thousands of dollars in savings, and it's one of the most important things for families that want to minimize intergenerational taxes. Unfortunately for Helen, by gifting 2/3 of the property to her daughters, they inherit her original basis, and now will have to pay the capital gains tax when they sell the property. Helen asked me if I could help her fix this because nobody had advised her of the tax consequences. Unfortunately, once you gift the property, you lose this tax benefit forever. So I was not able to help Helen. But I can help other people if I can get to them before they make mistakes like this and give them the full context so they're making the right choices for their family. So, a long time coming, one of the best tools to solve all these problems, to make sure that you're not losing money to taxes, to make sure you're not putting yourself at risk for creditors in other people in your family, and really to keep your property out of probate court and out of conflict, so you have the experience that my grandparents had, as opposed to the experience that the other side of the family has, is to create what's called a revocable living trust. Now, there are a bunch of different kinds of trusts out there. Many are irrevocable, meaning that once you create them, you can't easily get rid of them. Some of those trusts are used for Medicaid asset protection planning. Some of them are special needs trusts, and some of them are there to deal with advanced planning issues like estate tax. I'm talking about the most straightforward trust, the revocable living trust, that is really there to keep your assets outside of probate. And I like to think of it as sort of a container. It's a container that holds assets that don't have beneficiary designations. So what do I mean by this? Cash accounts, real estate that's held in your name or the name of you and your spouse, businesses, taxable investment accounts, stocks, bonds, other types of assets. All of those assets, if you just own them in your own name or if you own them as a couple, when you pass away, there's no directions on what happens to them. So that's why probate court is necessary. If you put a trust in place and you retitle them into the trust itself, it now has a container. There's now a legal agreement that holds them and keeps them from having to go to probate court. You nominate what are called successor trustees or backup trustees, basically people who will step in and administer the trust, decide who gets what, read the document, and basically do the work so that the court doesn't have to get involved. So really what you do there is you create a trust, and that's where we come in to help you fund the trust properly. If you recall back to my story about the refinance, a lot of attorneys will create trusts, but very few will actually have a system in place to hold you accountable, to keep you organized, to make sure that the right assets get owned by the trust. And actually, if you want, you can hire us to actually move the assets into the trust for you, so that there's no possibility that they're ever going to go to probate court. So we do things like sign new signature cards for bank accounts. We have a title company, so we can move all your properties into the trust. This is especially important for real estate investors out there, landlords out there who have multiple properties, and especially if you have multiple properties in different jurisdictions. If your property in Florida, Maryland, DC, and you don't have it in a trust, and you have it in your individual name when you pass away, unfortunately, your family is going to have to go ahead and open up separate probate proceedings in each jurisdiction where you own your property. So that's going to add a lot of time to the process. It's going to make it a lot more expensive and a lot more burdensome for your family when they would rather be grieving or coming together and connecting emotionally. Again, retitling investment accounts. If you have bonds, and personal property, we also work with life insurance retirement accounts, but there it's slightly different. For retirement accounts and life insurance accounts, they are beneficiary designated, so we don't actually change the owners of those accounts, but we talk about what happens when you pass away, who would be the appropriate beneficiaries. And I guess really quick, I'm going to go back to that real quick. This question here, I think I got a sense from some of you, but who here has heard of a revocable living trust? I know that some of you have, but if you can kind of give me a little bit of a sense of yes or no, whether that's a concept that's entirely brand new to you or whether it's something that you've heard of before. Because one of the things I'm going to do at the end of this, I'm going to share another webinar. It's a recorded webinar that I've done, and it's really about trust-based planning. It'll give you some more details about that that'll make it concrete. So let's see here. I'm definitely getting some yeses. Okay, a lot of yeses. I feel like probably those of you who who know about trust feel more comfortable sharing than those of you who don't. And that's fine. You know what I mean? Do you like the webinar as well? Okay, I'm going to share with you at the end of this presentation how you can get in contact with me and how you can get that webinar as well. I appreciate that. I did want to touch upon one last thing here, and this goes a little bit beyond creating a revocable living trust. This is those of you who have minor kids or you have beneficiaries that you'd like to inherit some sort of assets, but you don't want them to get outright distributions of cash, either at the age of 18 or even later on. For those of you who have people who are bad at managing money, or perhaps married to somebody or with somebody who you think might take the money from them, or if you just have a philosophy that you want that money to be passed on in your family, there is another option out there rather than outright distributions. I call it creating a lifetime asset protection trust, and it's an irrevocable trust that gets formed only upon your death. We plan for it now, but it gets formed upon your death or the death of both you and your spouse. And what this does is we put an independent trustee who manages the assets. And then your kids and beneficiaries at a certain age, they get the ability to self-manage, assuming that they're responsible. But the assets inside that trust are actually not part of their estate. And they are completely protected from creditors, predators, ex-spouses, lawsuits, etc. So it provides asset protection that's very valuable. And if your kids are so fortunate to end up having estate tax issues of their own when they pass away, these assets won't be part of their estate, so they won't even be counted towards that. It's kind of a complicated concept, and I'm happy to talk with people about it one-on-one, but it's a really valuable one for a lot of people. And then finally, estate taxes here. So just as a kind of a summary, federal estate taxes right now are at the highest that they've ever been, the threshold, I should say. It is right now about $12 million you'd have to have before you're going to get subject to federal estate taxes. If you have more than that, anything above that is going to be taxed at 40%. So it's a big issue for some people. More importantly, that it's slated to come down in 2025. But if you are in Maryland, the threshold is $5 million. If you're in DC, the threshold is $4 million. So for those of you who have retirement accounts, who have life insurance policies that may add up, who own real estate, there's a lot of my clients that don't consider themselves wealthy, but they actually end up hitting that $4 million. So that's something that I'm happy to chat with you about too, about ways of minimizing estate taxes, if that's of concern. And then finally, I have to put this out here as well. What happens a lot of people do no planning or just create a will is they don't get organized financially, and they don't share with their family where their assets are. or how to access them, or where the passwords are and things like that. One of the things that I like to do, and I recommend you guys do it regardless of who you work with, is create an asset spreadsheet, create a list of all the assets, all the accounts that you have, separate them out by account type, and then have it directions on how people can access all of them, whether that's sharing passwords and login credentials or some other method. Because you can see $58 billion right now, assets being lost to state departments of unclaimed property. And that's just lost money. That's just money that someone may have a cryptocurrency account. Someone may have had a Robinhood account, something like that, and they never told their kids and never documented it. So it just is lost to the family. So don't let that happen to your family, your client's family. Another thing that I like to do, and this again is not typical of estate planning attorneys, is I take the view that estate planning is about more than just passing on your physical assets. It's about passing on your stories and your viewpoint and the shared wisdom maybe that you have with your family. So what I ask my clients to do at the end of our process is I'll conduct an interview, and I give them a whole bunch of questions they can choose from, questions about their family, their kids, their spiritual beliefs, their religious beliefs, their stories, and they pick about half a dozen of them. And I ask those, and they share them. We keep a video recording of those or an audio recording. And that interview gets passed on from generation to generation. And it's particularly impactful for parents with minor kids. So the kids would have more than just money or assets. They would actually have a recording of their parents' values and their thoughts about them and their hopes and dreams and so forth. And it can sound a little bit woo and a little bit kind of out there. But for me, actually, that can be some of the most, really, I really appreciate I know my clients better when they go through that process. And I learn a lot about the way that they value their family, their experiences and so forth. And it's a really great way to connect with them emotionally. And it's a great exercise for them too. In a certain sense, my ideal way of looking at estate planning is getting people past the confusion and the fear of what they're not doing anything or worried that what they're doing is inadequate, to a place that they feel comfortable and they know what's going on and they're not worried about anything bad happening to their kids. People are going to be protected, but potentially also then getting to a place of saying, hey, when I retire here, I know my kids will be taken care of, but what about the broader community? What do I want to do with my golden years? Is there a way for me to give back to the community and get more engaged emotionally during my 70s, 80s, 90s? So I'm involved in philanthropic activities. It can be the arts, it can be your church, it can be whatever it is, so that your estate planning becomes less about dumping assets when you die and more about your own life cycle. You're kind of realizing that you are going to die, because we're all going to die, accepting that, and seeing the journey, seeing that part of the journey as one where you're giving back to your community and not being afraid of death, and in fact feeling like you are actualized. You are doing what you can at that stage in your life. So I just like to point that out there, because estate planning does not have to be depressing. It can be inspirational too. It is for me typically. So a little bit here, we talked about this before. Doing do-it-yourself plans and so forth can often give the illusion of being protected. And it often won't serve you. It's not going to serve your clients. So you want to work with somebody who is going to really take the entire context of your family situation, your financial situation, and the law into play, and design a plan that's going to be custom fit for you. And you're going to want them to be upfront about fees. I don't recommend practices with billing who bill by the hour. I have a flat fee practice, and I think that's really important. But it's just something to consider when you're looking for solutions for yourself. And I'm going to talk a little bit about, if those of you out there who want to take action beyond this webinar, we'll have a Q&A at the end. But if you want to take action, if you want to get past procrastination yourself and actually do something for yourself and your family, or for your clients and for your business, I offer a couple of ways that I can help out and I can get involved. The most direct way is to schedule a family wealth planning session with me and with my team. And that's a 2-hour working session where we're going to review your assets, review your potential beneficiaries, talk about potential fiduciaries, and come up with a custom plan that's going to work for you and your family. And I'm going to talk about how you can actually get to that point a little bit later on today. So, this is my incentive. I always try to give people financial incentives to move forward through estate planning. I charge $750 for that 2-hour meeting. Our fees, to be fully honest, we're not the cheapest game in town. They typically range between $2,000 to $8,000. Depends on the complexity of your estate, depends on if you're single or have minor kids. And you really choose during that meeting, you choose the fee that's going to be appropriate for you. You can choose what you can afford. And if you need to do more, you can come back later and do more. But my offer to those of you who are here today is, I'm going to give you an ability to come in and waive that $750 fee, plus get an additional discount. I do like to point out that, there are some of you here that probably don't need to come to see me. The slides here are a little bit tongue-in-cheek, you can see. But I think, really, you don't need estate planning if you don't care what's going to happen to anyone or the world after you pass away. And there are some people out there like that who just really don't care. So, they don't need to see me. I do think most people care, regardless of that, about what would happen when they become incapacitated. So I do think it's important from that perspective. But there are other people out there who are just getting started in their careers. They're young, they're healthy. They may be okay with doing some estate planning by themselves, or seeing an attorney who's more of a transactional attorney, but may have a lower price point. But for those of you who actually need a real relationship with your attorney, that's where I'm here to help. And I've got a Willy Wonka style golden ticket to help people here get past their procrastination and take action. And basically what that is offering a free family wealth planning session to anybody who's here on the webinar today. So I'm waiving the $750 fee, as long as when you schedule the appointment, you complete a questionnaire and submit that to me at least 2 days before our meeting. And the questionnaire just helps us get organized, helps us have a productive meeting. I'm also, especially just for people that are on this presentation right now, giving a $250 discount off of any eventual planning fee. That's above and beyond the $750. So it's a Thursday, it's in the afternoon. So I'm going to say anybody who contacts me by Monday, close of business, will get both of these. So if you're interested in doing that, I have 4 to 6 new clients that I take per month. So if that's really a priority for me, please let me know. So next steps real quick. We don't have any worksheets here, but what I'm going to say is that, so go on to the next thing here. What I do have is a QR code. So for those of you who have smartphones, go ahead and scan the QR code, and you'll see a few things there. You'll see there'll be a calendar with a link where you can schedule a family wealth planning session. That's great. If you're ready for that, then go ahead and do that. Some of you won't be ready for that. And if you're not ready for the actual family wealth planning session, you can schedule a 15-minute call. And the call can be just to discuss, some of the personal aspects of estate planning for your family. The call can be to talk about how we can work together to help your clients. Or if you're interested, I do like to co-host events with agents or their offices if they're looking to educate their clients. So go ahead and schedule a call with me as well. And that's a way that we can communicate that way. I am actually going to be out of town for a week, so you may notice that there's not a lot of slots available. What I'd ask you to do is, if you're interested in communicating with me at all, with me following up, share your email address and your name in the chat. And the folks here moderating are going to share that share that chat with me. And that's going to allow me to do 2 things. I can follow up with you personally, and I can also, if you're interested, put you on my newsletter list where we have monthly articles that come out on things that I think you'll find really helpful. So if you let me know if anyone's having any challenges with the QR code too, because technology can be tricky sometimes. But play around with that, see what you can do, and also share your email address in the chat. And it seems like we have plenty of time here, so I'm gonna work now. While we have this up here, we can go ahead into the Q&A. I'm taking a look here, and if Humira, if you'd like to chime in here at all, we can go ahead with some questions, or I can just read them from the Q&A section, whatever you prefer.
So this is really great. So first question that we had, you touched a little bit about it, was the irrevocable trust versus irrevocable.
It's a
We'll
tongue
talk
twister,
about
right?
it. In reference to having control of the trust and what's in it. So that was from Givens.
Okay.
And I think that might be something that you can touch on. Maybe you guys connect a little bit more to have conversation on that.
Yeah, I can give a brief overview. Basically, so a revocable living trust is because it's revocable, it is a pass-through entity. You set it up, you're the grantor, but you have total control of your assets. You can amend the trust, you can restate the trust, you can revoke it, you can change it at any time. You don't lose any control, and there are no real tax implications. On the flip side, an irrevocable trust, once you put the assets in that trust, you are giving up a lot of control. So a lot of people don't like that when it comes down to it. You don't want to lose control. And that's why the irrevocable trusts are used in specialty situations where the cost of losing control is offset by the benefit of putting it in the trust. And the benefit may be qualifying for Medicaid for long-term care while still protecting your money. The benefit may be avoiding estate taxes. The benefit may be putting something away for a child that has special needs so they can have that money but still get their federal benefits. So there's a whole variety of them. But typically I start with a revocable living trust as part of foundational estate planning and then build on from there.
That might be a topic all on its own, because it seems like there's a lot involved in that.
Yeah. And I go into that. That could be another presentation, or I could go into that during the family planning session as well.
That sounds really good. So we had two statements. I think one was they were nearing retirement and they own a rental property. So I'm assuming they kind of want to know how to figure out how to set that up for their family for the future. Another comment was for their own real estate and to avoid probate court for their family, as well as avoiding capital gain taxes. So you kind of touched a little bit on that.
Yeah. I mean, I think what it is really, if you own rental properties, you know, the first step is going to be, you may own them in your personal name, you may own them in LLCs, some of you may own them in partnerships if you're in syndications and so forth, but basically the revocable living trust can wrap around your properties. It can wrap around your personal names, or it can wrap around your LLCs. So the first goal is to get the property or your share of the property, if there's multiple owners, into the revocable living trust, so that when you do pass away, there's no probate process, that everything gets distributed out of probate. That's number one. Then we can talk about how better to structure your real estate holdings to give credit protection, to avoid lawsuits and things like that. That's a separate conversation, but it's a great conversation. I love having that with my real estate investors, because I invest too. So it's one geek to another.
We understand that.
Yeah, you know.
Yes.
Our
Our next question. Yes. Our next question is understanding and guidance for trusts for themselves and their clients, and they're not sure how to set up a trust if a property is currently is mortgaged.
That's a great question. If you're talking about an irrevocable trust, it gets complex. But for the revocable living trust and avoiding probate, the mortgage companies don't have an issue with you transferring title to yourself, to the trust itself. Because it's a pass-through entity and so forth, there's no risk change for them. So we can set up a trust for you. We can deed the property into the trust. There's no transfer taxes, no state taxes, nothing like that. And you're not going to trigger the due on sale clause that the mortgage company has. So that's good news.
Elements of a great estate plan.
What are the elements of a great estate plan? Well, I think I've touched upon a lot of those. I'm not going to do a list of documents, because if you would see one of my portfolios, there's well over a dozen documents. I'm going to think about it more in terms of like the outcome. You've got a plan in place for your kids, be they minor kids, kids that have just turned 18, or kids that are grown. You've got a situation where when you pass away, everybody knows who's getting the assets and they're not going through probate court. You are not wasting money on taxes or on lawyers, and there's no big surprises to your family. And you're working with a professional who can continue to guide you as your living situation in the law changes, so that a plan that you put in place in the past and thought was going to work is going to work, because you're going to continue to work. You're going to continue to consult with that person. And I think a big one also when it comes to assets is that sometimes people will put their assets into the trust, if that's what they're doing, and then they'll go ahead and they'll purchase more assets and they'll forget about the trust. They'll open up accounts in their own name, or they will buy real estate in their own name. And so having those, like we have a complimentary 3-year check-in. We have meetings again with our clients. Having those check-in meetings and having an updated asset spreadsheet so that there's never anything lost will allow us to identify if anything needs to be fixed, if the title should be transferred. So I think those are elements of a great estate plan. I would also talk about and advocate thinking through what your life cycle means to you, thinking through what your family and what you want your legacy to be, and not being afraid of death would also be a really awesome estate plan.
Understood. Now we've got a similar question from the previous one, and just to clarify, so if the property is in a mortgage, they can put it in a trust, but should they put it in a revocable trust versus an irrevocable trust?
Generally speaking, I would say put it into a revocable trust. If you have a specific need for an irrevocable trust, we would talk about that above and beyond. It has nothing to do with being in a mortgage. So yes, start with a revocable trust and then build on it from there.
Does the trust planning require that they get an appraisals of art, coins, jewelry, or would you be able to provide like resources for that appraisal?
So it's not necessary. We provide, documents and so forth that assign your personal property to the trust automatically, so those items don't fall through probate. We also provide a little bit of a system for you naming who would inherit each particular item, heirlooms and things like that. But I do have some clients that are like art collectors that have like, one of them has like a $2.5 million art collection and things like that. If you have collections or other personal assets that are very valuable, then yes, I do have resources for people who can help you with appraisals, help you with the right kind of insurance, help you make sure that it's very, very well documented, so that because if the majority of your wealth is in those kind of items, we want to treat them very separately.
Understood. I am the trustee for my sister in the state of Virginia. Was there any way to avoid the bond that is on the trust for its lifetime, or is that only the law for Virginia?
So you're the trustee. If you're the trustee for your sister, I have to talk a little bit more, but I'm assuming that your sister's passed away and this is post-death administration. Typically, if you go to court, typically there's a bond that you have to post in probate court. I would say there's some flexibility when it comes to being to trust-based planning. So there's no probate court. Usually you can get around having to post a bond, but I'm happy to follow up with you specifically about that question.
Yes, if you could, and I'll make sure that you guys get connected
Right.
to that. Yes. Let's see. If the property is mortgaged and it's placed in a revocable trust, is it protected from creditors? Just like
no, that would be too good to be true. One of the jobs of your trustee when you die is going to make sure that you do pay your creditors. So for example, if you've got a $500,000 home and there's a $200,000 mortgage, they're going to have to pay your bank off. You can't get away from that. Same thing with liens when they go to sell the property. I will say there's some flexibility when it comes to consumer debt. So some level of credit card debt and things like that, we can get a little creative and perhaps get the credit card companies to go away. But for major mortgages and debts like that, the revocable living trust is not going to be the tool to avoid those types of things.
Understood. If I own a home before I get married, does putting a home in a trust protect from spouse in the event of a divorce?
Putting it into a revocable living trust, that's a separate trust, can help. Yes, I would not put it into a joint trust. if you're going to be, if you are going to get married and you want to keep your separate property separate, we put it into an individual trust, and we make sure that we don't commingle those assets. I would also recommend getting a prenup in place, because the state, when you do get divorced, and if it's litigious and so forth, having a prenup or postnup is an important piece of making sure that the assets aren't commingled.
Understood. Uh, can you use the property equity while the property is in a trust?
Absolutely. Yep, you can use it the same way you would if it was in your personal name.
Um, how often should we review the trust? And if we have changes, what is the best way to go about that?
So I like to say at least once every 3 years is a good time to just review it. And if you're going through any life changes, deaths, divorce, moving to different countries, for example, that would be a good time to check into the plan as well. And in terms of how to change it, when it comes to the trust, it would just be either an amendment to the trust if it's a small change, a trust restatement if it's a bigger change. And then also there are going to be ancillary documents, your powers of attorney, your guardianships, and things like that. We can change all of those.
Interesting. That's good. If the property is in a trust, are you personally protected from being sued for any reason?
No, not in a revocable living trust. So I'll talk about that a little bit, because if you're an investor, you're kind of curious about this. So if you're an investor, you're buying properties, you're probably starting out putting them in your personal name because you at least in the past, could get cheaper conventional financing. Then you graduate to the point where you say, wait a second, it's getting tough to qualify for these loans. My debt to credit ratio or I'm self-employed. This is the underwriting's taking too long. Then you start creating LLCs for your rental properties, and you probably get commercial debt, like for example, a DSCR or debt service coverage ratio loan. The interest rate might be a little bit higher, but it's a lot easier to get. And one of the benefits of being in an LLC is that provides a level of credit protection, so that what happens in your rental property there, if there's a lawsuit inside that rental property, it's much tougher for creditors to get at the rest of your assets, your personal real estate, your retirement accounts, your family's wealth, and so forth. So separating investment properties into LLCs is part of that. Another is going to be having a homeowner's insurance policy. Another is going to be having an umbrella policy. So those are things that you can do to help mitigate lawsuits and so forth. I'll put this in there, if you are an investor who has a lot of properties, or if you're a real estate developer and you have a lot of risk, I would not recommend this for anyone until they have at least $5 million net worth. So it's not going to apply to everybody. You can create what's called a domestic asset protection trust. I'm not going to get into the details about that, but that's an irrevocable trust where you put some of your assets, and it provides very strong creditor protection. I have a couple of developers that are developing hotels in the DC area. As you can imagine, they might have a huge amount of assets and net worth. And what we do is we actually set up domestic asset protection trusts, and we put some of those assets in there so that they're totally protected from any creditors. But that's a very advanced technique, and it's expensive, and it's tough. So
Understood. I think we have a couple more questions left. I lost my mom in 2021 interstate. Is it too late to create a trust for my siblings and I? And can I still put the property that has a mortgage on that in a trust?
So if you lost her a couple of years ago, what would happen is that if you haven't yet, if she has any assets, they would go through probate court. And it is too late to create a trust to avoid that process. Unfortunately, when someone's passed away, it's too late to do that. You can still create it for your own assets or for your siblings, or if you inherit that property, you can put that property into a revocable living trust so that for the next generation, they can avoid the probate process. So no, once someone's passed away, the window for that has closed.
Understood. If my property's tenancy is joint tenants with the right of survivorship, does it go through probate if I die?
Nope. That's kind of back to my story with Helen. Joint tenants with the right of survivorship is a way to avoid probate. So for example, if you and your spouse own it by either tenants by the entireties, which is typical for that, or joint tenants with the right of survivorship, if one of you passes, it goes directly to the other. which is superior. So you have no probate situation there. If both of you pass away, then it goes to probate.
If is it difficult to switch attorneys if you already have a trust but not pleased with them?
So basically switching attorneys, I mean, you could always switch a new attorney. My recommendation is, you know, the one type of, it's difficult to take on a new attorney if you're just looking for little changes. Like if you're working with one attorney and you got the majority of your work done and you're just not happy with them anymore and you want tweaks, most attorneys aren't going to take you on to play Mr. Fix-It, to do little tweaks to other people's plans. Some people will. So when you make a change from one attorney to another, it's kind of like it's like breaking up or getting divorced and getting married again. It's sort of, you're committing to a new relationship. And you should do that only if you really feel like your current relationship, your current attorney relationship isn't serving you and your family.
Understood. How do you remove investment properties that have been sold from the trust?
So if you sell an investment property, it will automatically come out of the trust. So for example, if you have a property that's held in your personal name, let's say it's an investment property, and you've put it into your trust, now it's owned by the trust, you will simply, in the contract, the seller will be your trust, with you as the trustee. The buyer will be whoever it is, and that automatically takes it out of the trust. If you have your property in an LLC or another corporate form, you actually don't have to change anything in the land records. You actually execute, we help you out with this, of course, a private document called an assignment of membership interests. So basically you have your property, you have the LLC here, and we execute a private document called the assignment of membership interests, and that puts your entire LLC, the business, into the trust. So actually for more advanced investors who have most of the properties held in LLCs or series of LLCs or in holding companies, the estate planning part of it gets a little bit easier. It becomes easier to organize.
So if you can still put the property in a trust, then get umbrella insurance. Is that correct?
Yeah, absolutely. And I recommend you do.
And is joint tenants only for married people?
No, you could be joint tenants with like your brother or sister if you wanted to. You know what I mean? You could go into a property together. It could be like with an unmarried partner, your spouse, your significant other. But there is one particular kind of tenancy that's called tenants by the entireties, which provides a little bit more credit protection, and that is only for people who are married under state law.
Okay, so does putting rental properties owned by an LLC and then putting that LLC in the trust also protect the property, or should I put the property solely in the trust, or can I put both?
You do both. Just kind of what I said before is you held it, you deed it to the LLC. So if you do a search of the land records, it's going to be held by XYZ LLC. And then you have a private document that assigns the LLC to the trust. And that way you get the benefit of both the credit protection and the probate avoidance. So that's kind of the silver bullet there.
And is it better to put the investment properties or rental properties in an LLC or a corporation?
I would say typically LLCs are good for investment properties. It may be if you get to a point where you have a portfolio of investment properties and you want to have a property management company, or you want to have other types of like operating businesses that service those properties, then it may make sense to have corporations that play around. Or you could actually put all of your LLCs into one holding corporation. That's a more advanced strategy, but that may be appropriate for people who are professional investors. You don't have a day job. You own 12 properties or 24 properties, or you own 3 multifamily properties or commercial properties. Then we can talk about holding companies.
Thank you so much. I know we still have questions still coming in. I think we're over our time, but what we're going to do is send us your questions. We have them. We'll work on getting them answered even after the seminar or the webinar is over. Thank you so much, Scott. And those of you who have attended, thank you so much. Please leave your feedback Because I
Yeah.
feel like this could become into a little bit of a series that we could do because there's different
Well,
parts of
there's a
it.
lot there. This is like foundation,
Yeah.
you know what I mean?
Yes. And I apologize. You hear my toddler now screaming in the back because he's seen me. But thank you so very much. And I think, thank you, Scott, for coming on and giving us such valuable information.
Sure.
And I think we might turn this into something, Renata and I will, will get back to you on that.
Okay.
So thank you so much. This was awesome. We appreciate you coming on and spending some time with us. Thank you, everybody.
Thank you all. Take care.